like to welcome all of you for, I could do this in German because our guest is fluent in German, but we have another guest, of course, and therefore we do everything in English today. I'd like to welcome you to our last Law After Lunch session this semester, again with a guest speaker. This time, certainly the guest that has had the longest way in this semester coming to Halle, namely coming from Sydney, Australia. Angus Lang, but it's not his first time, so he knows the way by heart by now, because he's a regular guest at our university lecturing. I guess some of you took his class and are taking the class. We are very thankful and happy to have you here, Angus, as always. But as always, I say that with strong confidence and very happy that you came. Angus is going, as you probably most of you know, he's a barrister in Sydney. Maybe you say some words on your professional background by yourself. And he is a specialist on intellectual property law. And thus we are going to discuss something which is not there yet. It's a kind of a virtual talk in this regard, because negotiations on Australia-EU Free Trade Agreement just started. We had the mandate from EU law perspective last year, and the first round of negotiations just 2 weeks, 3 weeks ago, something like that. So we see where this ends. It's an old story. We had a lot of arguments on human rights and wine and geographical and so on and so forth, but we will learn about that from Angus.
Thank you. Thank you. Herzlich willkommen bei diesem Vortrag. Das ist wie gesagt ein englischsprachiger Vortrag, also wechsle ich sofort ins Englische, or to be more precise, Australian, because as the professor said, that's where I come from. I practice entirely in intellectual property law in Australia. But I want to stand back a little bit today and look at a somewhat more international topic, which is the Australia-EU Free Trade Agreement. You'll see in the title that I've described it as the Australia-EU Free Trade Agreement and the intellectual property lawyer, the jurist, as opposed to the law itself. Why have I done that? Well, in thinking about what I might talk about on this topic, I suppose naturally your thoughts are directed to substantive intellectual property law. And if you think about the substantive intellectual property law aspects of the Free Trade Agreement, then of course there will be an intellectual property chapter, and it will deal with things like geographic indicators, as the professor has mentioned. And so there will be much discussion about Parma, ham and feta cheese and sparkling wine and champagne and all of that. And so we could talk about all of those things. But I thought, you know, it would only make us hungry, and, you know, we'd just have our lunch. and to be honest, I find, for some reason, although I'm an intellectual property lawyer, I do find geographic indicators really boring. so I don't want to talk about geographic indicators. So what will I talk about? I'll be a bit more personal. I want to talk about how do things like the Australia-EU Free Trade Agreement affect us as lawyers? Our actual, think about the position of a practicing lawyer. Applies perhaps as well to academics, but think about the position of a practicing lawyer in Australia or in Germany. How will things like the Australia-EU Free Trade Agreement affect us, and in particular as a practicing intellectual property lawyer? And the sort of chapters that will be relevant to thinking about that topic are not so much the intellectual property chapter itself as other chapters, services chapters and digital trade. Now, I wanted to start off here with a press release from the peak services bodies in Australia and in Europe. So in Australia, the peak services body, which is a lobbying body for the purposes of international agreements, is called the Australian Services Roundtable. It's a nice name. and in Europe it's the ESF, the European Services Forum. They provided a press release not long ago, in June, which said this: beyond the headlines on agriculture and commodities trade. So it starts off by saying, yes, we know you're all thinking about Parma ham and feta cheese and wine and so on, but forget about that, because the ESF and ASR would like to remind the negotiators that trade in services has a bigger share of two-way trade than any other sector. For both partners, services make up over 1/3 of total trade. Goes on, emphasises the point that the two trading partners already have deep services business links. Services imports from Australia to the EU were 9.8 billion US, while services exports from the EU to Australia amounted to 22.2 billion in 2016. That year, the EU was Australia's top two-way services trade partner for the 16th year in a row. So we know Europe is the biggest services exporter by a long way in the world, and Australia is also a healthy services exporter to Europe as well. And then there's a quote from the chairwoman of ASR, Jane Drake-Brockman. For Australia, the services intensity of exports to the EU is especially high, higher than for any other trading partner with which Australia has negotiated an FTA. Services represent over 40% of Australia's total exports to the EU. That was the quote from Jane Drake-Brockman. Now, Jane Drake-Brockman gave a presentation recently at a conference in Sydney where she was saying some really interesting things about the upcoming negotiations. The conference in Sydney, by the way, was a conference of a Juristenvereinigung, a lawyers' association called the Deutsch-Australisch-Pazifische Juristenvereinigung. Did anyone here a member of that club? When I tell people about that club, people think I just made it up because, for myself, because there's nobody else in that club. But there are a few others. I didn't create it, but I did go along to it, and it was a really good conference with some really interesting aspects of the AEU free trade agreement that were discussed there. And Jane Drake-Brockman was there, and one area of particular focus between Jane and her counterpart in the ESF is that they're really focusing very much on services provided by way of data flows. So we have to think now about the way in which we want to regulate services which are provided not just by humans in a shop in a particular location in Europe and in Australia, but as will increasingly be the case, services provided by machines, including artificially intelligent machines, which may have hardware and software components. It might be a robot lawyer providing services in a particular location, which consists of hardware in a particular location, but increasingly the hardware will be irrelevant, and instead the services will be provided, the important aspect of the services to be provided will be by way of data flows. So the negotiators right now are thinking of these really very interesting futuristic scenarios. And when we think about services, we think with a particular focus on data flows. At least that's the way that the services bodies are thinking. So, firstly, what can we identify about that? Firstly, there seems to be a mutual interest in a liberalisation of data flows so that we don't have restrictions on data flows across national boundaries. And so in the EC proposal for horizontal provisions for cross-border data flows and for personal data protection, Article A embodies this will for liberalisation and indicates there some of the sorts of things that can act as restrictions on data flows and that ought not be permitted to do so. So the parties are committed to ensuring cross-border data flows to facilitate trade in the digital economy. To that end, cross-border data flows shall not be restricted between the parties by one, requiring the use of computing facilities or network elements in the parties' territory. Two, requiring the localisation of data in the parties' territory for storing or processing. Three, prohibiting storage or processing in the territory of the other party. And for making the cross-border transfer of data contingent upon the use of computing facilities or network elements in the parties' territory. So there are all sorts of ways in which data flows can be restricted, and that ought not to be under this proposal coming from the European side. Of course, Article A is only part of the picture. There is an Article B, which is a little bit controversial at the moment, which deals with the other side of the coin from a privacy and security point of view. But it's just indicative of a general will towards liberalisation of data flows. But of course, the other side of that coin, liberalisation of those data flows, is the question, so how are we going to regulate services being provided by way of data flows across borders? What do we actually have to do to regulate that sort of manner of providing services? And it's a topic that the world is just slowly starting to come to grips with. So it's being dealt with in a rather ad hoc manner in bilateral free trade agreements, and it will be dealt with in the Australia-EU free trade agreement in a particular manner. But it's the sort of thing that, of its nature, needs to be dealt with more ideally in a multilateral way, and so that also is just starting to happen. So following the 11th Ministerial Conference of the World Trade Organization, a coalition, there was no consensus that was reached in the WTO, but there's a coalition of the willing, within members of the WTO, 71 of them, including Europe, of course, and this is an initiative that's chaired by Australia, which is going to be undertaking exploratory work towards future negotiations in respect of e-commerce. So we're starting to recognise that the question of data flows is going to be increasingly important and that it's going to require a multilateral response. Okay, so that's services generally. Let's think about professional services, lawyers. So there seems to be, just looking at broadly, a common interest shared by both Australia and Europe in liberalising market access for professional services providers, including lawyers. So thinking firstly about legal services provided by human beings like you and me, there are sorts of things that can be done in order to improve the passage of or the provision of legal services in each jurisdiction by lawyers from the other. They are measures like mutual recognition of qualifications. I know of a number of German lawyers whose dream it is to be Australian lawyers. I don't know if any of you share that dream, but you have to really want it. You have to really want it because it's a hard path to travel. I know a number of people who have tried and given up, and a couple have tried and succeeded, but you really have to desire that goal because the actual recognition of European qualifications is really very poor in Australia, and you have to do quite a number of subjects over a number of years in order to qualify, if you're a German qualified lawyer, to actually qualify to practice in Australia. And it's also pretty difficult for an Australian lawyer to qualify to practice in Germany. I've sort of flirted with the idea myself, but you know, if you can teach, then why would you want to practice? So anyhow, so mutual recognition, it's got quite a long way to go. But think about the other sorts of ways that this can happen in practice. You might be a German lawyer who wants to do a particular transaction in Australia, say solar energy technology transaction, and so you want to fly in and practice in Australia for that purpose and then fly out. You need a visa for that, so you need improved visa for fly-in, fly-out type work, and potentially reduced restrictions on what entities are permitted to provide services, companies, partnerships, and so on. So there are all sorts of measures that the parties are thinking about in order to liberalise the provision of legal services, so as to allow greater mobility of lawyers like you and me to be able to practice in both jurisdictions. But by the time we get our act together on that, the robots will have taken over. So in the meantime, steps are being taken in the field of artificial intelligence, which are also relevant to the provision of legal services. So let's entertain ourselves, we'll indulge ourselves to think about what this might look like sometime soon. Maybe it will happen, maybe it won't. Let's have a little bit of a think about it. Here we are, we have Watson and we have Ross. Does anyone know who Watson is? Watson, an IBM machine. Watson is an Anspielung auf what? Sherlock and Watson? Yeah. So Watson's a clever guy. So Watson is an intelligent machine created by IBM, consists of natural language capabilities. If we've all interacted with Alexa or Google Home, we know what that is. And cognitive learning, so machine learning capabilities. So machine learning is pretty cool, it's pretty terrifying, but it's a process whereby machines learn how to do tasks a bit more like a human learns how to do them, rather than being programmed to do tasks. So machines have the ability to learn in a way that's a little bit like human cognition. Watson is a very clever machine that has natural language capability and cognitive learning. Human versus the machine. And the machine actually, so it was judged by a vote, and the machine won on a vote. There were many in the audience who were actually IBM Mitarbeiter who were working on the machine, so they were a bit biased. And if you do a bit of research, you found it was not perfect. So it did some strange things linguistically and argumentatively, but it also did surprisingly well. So it was able to put together coherent arguments, so it has to listen to someone, understand an argument, and put a counter argument orally. It's amazing, really, that the machine could even get close to doing that. But it's starting to happen. It's starting to happen. And so when I look at that, so I'm a barrister, and so this is me. That's my job. That's my job in court. That's what I have to do. And now I've got this guy as my competitor. So the barrister of the future, right there. So that was arguing, oral arguing. It's very much. I can't really stress enough how important that is to the practice of being a lawyer, particularly a barrister, particularly in the common law tradition. So, you know, we can get sidetracked today, or I could, on strengths and weaknesses of the common law tradition. A weakness is it's completely unmethodical. A strength is that it's very nuanced from a storytelling point of view. So case law is very nuanced, very human, very warm. And so the job of a barrister is to be a good storyteller, And now all of a sudden machines can be good storytellers too. Even a common law barrister could be substituted by a machine, possibly. But that was a non-legal context. Also in the legal context, we have some very interesting advances in artificial intelligence. That one down the bottom there, Ross, is one of them. Ross is a branded product that is also built on the Watson platform. So Watson's natural language capabilities and Watson's machine learning capabilities are being used. And it was some former employees of IBM who decided that they would prepare an application of Watson's capabilities in the legal research field. And so we can spend hours and days and weeks, can't we, as legal teachers and students, researching a particular topic. The idea behind Ross is that a machine would do that using natural language and cognitive learning capabilities and do it in much less time. And so far, apparently, it's doing very well. There's a commercial product available. Has anyone actually used a commercial product? I have not, but there is an intellectual property form of Ross that does legal research in an artificially intelligent manner. So that will not replace a barrister, but the idea is it is doing work that human lawyers do, and doing it better. It seems to be doing it better and faster so far. So here, what have we got? We've got arguing, oral capabilities, and we've got legal research capabilities. There you see in Project of Beta, you see a piece of hardware, a physical object that might be located in a particular place. But increasingly it's the software that's the important part of this service. And so ROS is a software type solution. It's a sort of solution that could be run from a server anywhere in the world, communicated anywhere in the world. So, in our imagined world of liberalised digital trade in professional legal services, does this represent a dystopia? A dystopia where suddenly we humans have no work anymore and we're forced to compete with artificially intelligent machines. Forced to compete with machines, and they're not even here. They don't even have the politeness to come here and look me in the face when they compete. They're sitting on a server somewhere else and provided by way of data flow. And also, they're not even the subject of my laws. So how will they be regulated? They might be regulated internationally by international norms. A very different sort of world from the world that we currently are in. What is the world that we're currently in? Let me just tell you a little bit about what practice in intellectual property law looks like in the status quo right now. So, from the perspective of an Australian intellectual property lawyer, we tend to like the fact that intellectual property laws are national laws. So if you have a patent and you have a competitor who's infringing that patent and they're doing that worldwide, then of course what you have to do is sue that competitor in every jurisdiction worldwide in which you want to stop them. So you've got to go to the courts in Europe, go to the courts in America, go to the courts in Japan, Korea, and Australia. Australia is a very small market, in particular compared to the cost of litigation in Australia, but you will go to the courts in Australia because you want to stop that competitor worldwide. And so Australian intellectual property lawyers have work to do because of national intellectual property laws. If our cases were decided elsewhere by some other court or by an international court, then there wouldn't be much of an intellectual property practice in Australia, it being such a small market. So we have local lawyers who benefit from fairly restrictive qualification regimes, as I discussed earlier. We have domestic intellectual property rights adjudicated by domestic courts. So I've looked then at who might be the intellectual property lawyers of the future, but what about then on the side of substantive law? Will we continue to have domestic intellectual property rights, or is that changing as well? The answer is that is changing as well, at least in the field of patents. And so while all of our free trade agreements are developing, alongside of that, there are other international efforts occurring, and in particular the one that I wanted to focus on is the harmonisation project for patent law. So patent law is an area where there is an international will to substantively harmonise the law across the world, and it's one where it's realistic to achieve it. It's quite hard in areas like copyright, perhaps trademarks as well, because the political foundations are much more controversial and jurisdiction specific, but in patents, more or less everyone wants to achieve a similar sort of result by similar sorts of means. There are, of course, significant differences, and they will take a long time to deal with, but we think maybe it might take another 10 to 20 years to get a good international harmonisation of patent law. Here are the international groups currently dealing with it. It started in 2011 with the sogenannte Tegensee group. There's Tegensee. That's where that's a nice sort of metaphor for patent harmonisation, sort of up high there in the Bavarian Alps, looking on the whole of the world. So eine herrliche Landschaft. And then from 2015 onward, Group B+. I got to go, it was so exciting, I got to go along as part of Australia's contingent to a Group B+ working group in the European Patent Office. It's like Mecca for an intellectual property lawyer to go to the EPO. I was very excited. And it was really interesting to see that there is, in fact, a genuine international will to harmonise patent law. You had US-American lawyers saying, yes, we know our law is different, but we're going to change it. It was astonishing. No, I didn't expect that at all. And also the Europeans, who've been stubborn on some particular points, look like they want to compromise. So it seems like that will happen. Once you have harmonised patent law, it's then a fairly smallish step to having a single unitary patent. And we kind of know that from the European experience, where Europe started with a harmonised patent law. The way that that was embodied was having individual patents in different parts of Europe. So you go to the European Patents Office, get your European patent, it becomes national patents. The reason that took so long to become a unitary patent was, there are a few reasons, but language was a big one. So practically, how do you deal with the fact that you are getting a patent for the whole of the European area, but you don't necessarily want to have patents in every language of the European Economic Zone, and how do you deal with that? Eventually that problem was solved. So what are the languages for the European patent? German, French, English only. I think the Italians and the Spanish are upset, but that's the solution. So, small step from a harmonised patent law to a unitary patent. So, are we progressing towards a unitary international patent? Maybe we are. You certainly have to think that's a possibility. Then, another step from there is once you have a unitary patent, the next obvious step is you have a single international patent court. It doesn't make much sense to have domestic courts all adjudicating differently a single unitary patent. And again, Europe presents an interesting analogy here, because with the community patent you also have the unified patent court. How might that look in the case of a unified international patent court? Well, let's have a look at how it looks in Europe. So in Europe we have a central division which is to be in Paris, pharmaceutical focus in London, immer noch. and it will still happen. Mechanical is Germany's special area of interest. Then there'll be regional, so divisions not by technology area, field, but by location. Regional divisions in certain member states, including Germany and others. There'll be a court of appeal in Luxembourg, the registry of the court in Luxembourg. Training of judges will happen in Lisbon and Budapest. And then there'll be arbitration and mediation centres in Ljubljana. So there you have a single court, but participation by a lot of different jurisdictions in Europe with different aspects of that court. Interesting. Languages, as we know, that was a particular problem in Europe that's now been solved. How might that look then on an international level? Well, couldn't you do something similar? So you have particular registries of the court that are responsible for different fields of technology in different parts of the world, responsible for different regions of the world, single unified patent court with many registries, an appeal division in a certain location, arbitration and mediation centres in certain locations, training of judges in other locations. So you have a single unified court, but with distributed functions in different parts of the world. Again, maybe not, but maybe, possibly. Possibly. Does that mean that for an Australian intellectual property lawyer or a German intellectual property lawyer, that will be the end of national intellectual property work? Well, today, sitting here, we can sort of look at all of that and think a few different things. One is, this is just not happening. I'm going to put my head in the sand. And that's okay. That's a fair reaction. Maybe it never will happen. Or maybe by the time it happens, you'll be retired or dead, maybe. And I've spoken to some colleagues in that category in Australia. They say, oh, Angus, interesting thoughts. Oh, I'm going to be long gone by the time that happens. I don't really care. Another reaction I get from Australians when I've chatted to them about this is fear. They say, oh, Angus, yes, I think you've got a point. Yes, I can see that probably is something that might well happen. Let's stop it. Let's stop it happening. We don't want that to happen. That will be the end of life as we know it for intellectual property lawyers in Australia. Okay, fair enough. Or another possibility is saying, yes, I think maybe something like this or parts of it might happen, and maybe there are some good aspects of this, and maybe we can participate in it as intellectual property lawyers, participate on the international plane. It doesn't happen very much, actually. But participate on the international plane and see if we can shape it in a way that's desirable. So what might that look like? Well, just going back to our legal robot, our artificially intelligent lawyer. How can a human lawyer participate in the development of the artificially intelligent lawyer? Well, the first really interesting aspect of this is you won't now just have intellectual property lawyers, you'll have intellectual property in lawyers, because these lawyers are themselves technology, which will be the subject of patents. You can imagine that this might be an area in which there are standardised and non-standardised aspects of the technology. So if you want to create an artificial lawyer that practices in German law, you will need it to have a minimum level of competence. So there will need to be a standardised set of algorithms for a German lawyer. So you can insert the German lawyer module into your machine and it will be a competent German lawyer. It will know the BGB, it will know some other German norms, it will be able to find the right norm, and it will be able to apply it in certain ways. So it will have standardised aspects of its knowledge, but just like standardised aspects of other machines, like our smartphones and so on, standards don't regulate all aspects of how they operate. They regulate a lot of how it operates, but not everything. They allow rooms for better and worse implementations of functions. And so there will be proprietary aspects of the way that these machines work. And that is the case for Ross, and it's the case for Watson. So Ross have got patents over the way that their machines do intellectual property research, proprietary algorithms that they use for their legal services. So there'll be patents in patent lawyers, patents for patent lawyers. And so as a lawyer, now you can be an inventor of a patent. So you can be a participant in the development of artificial intelligence for lawyers. You can own patents in artificial intelligence, and you can prosecute them, you can enforce them, and so on. So I think it very much changes or provides an additional area of activity for human lawyers that we might be interested in thinking about in that world of artificial intelligence. Still scope for us to do interesting things as intellectual property lawyers in that world. Turning then to the away from digitalisation to the other aspects of internationalisation of intellectual property disputes. As I mentioned, yes, you might take away the competence of national courts. You might take that away from the current national courts that adjudicate on intellectual property rights into an international patents court, but that doesn't mean that patents court is just going to be sitting somewhere else in the world and you have no involvement in it. So a local jurisdiction like Australia, a well-trusted intellectual property jurisdiction, should, in my view, be thinking about positioning itself for the operation of a registry of an international patent court, or at least for membership of the judiciary, and similarly for Germany. Very, very long heritage of patent litigation in Germany, very well-trusted judiciary, and a heritage of intellectual property law. And for those reasons, Germany is a pillar of the Unified Patents Court in Europe, and ought also to be in the case of an international patents court. It'd be interesting to know what Germany's position would be like in terms of language in an international patents court. So Germany was one of the winners from a language point of view for the Unified European Patents Court, but would it be linguistically in an international patents court? So there, the Spanish might get their own back. It might be English, Spanish, Mandarin, might be the three languages. Who knows? So those are things to be thinking about from the perspective of someone who's interested in persisting in intellectual property work for disputes in a potential future international context. That is, shouldn't we be thinking now about creating that sort of area where we might be a respectable candidate for some function of an international patents court? And then just returning, finally, on the topic of international courts and the Australia-EU Free Trade Agreement. I wasn't really talking about the Free Trade Agreement, was I, in this topic? What's going to happen to ISDS in the Australia-EU Free Trade Agreement? It is, I think, been quietly left out of the scope of negotiation so far, if I'm right. Will it be contained in a separate agreement somehow, an ISDS? I think that might be possible. And also, what's the fate of ISDS and the investment court proposal in Europe? At the moment, that's unknown with some well-known case law that's happening right now. Of course, in this particular field as well, this is an international forum, ISDS, and it can have significant consequences for substantive international and domestic intellectual property laws. You need only look at the recent decision of the WTO panel in the Australian plain packaging case to see just how much that international decision-making body has to consider and deal in a very nuanced way with national intellectual property laws. It's very, very interesting to see, and also represents something that national intellectual property lawyers now are dealing with some trepidation, got some concern about the way that ISDS decisions are made and their effect on national intellectual property laws. Well, one thing we can do, which I think has not been done yet, is that on things like the WTO panels and the ISDS arbitrators, there ought to be intellectual property lawyers, a good intellectual property law experience. It ought to be guaranteed as part of your panel. There's a little bit of a concern that doesn't exist, that at the moment the sort of decision makers that you get in those forums are some of the old hands that everyone knows who perhaps may not be the best decision makers in the intellectual property field. So having particular mandatory expertise in that field is another area where intellectual property lawyers might find their activity in the international context. So it only remains to thank you for your attention. I can see some of you are old enough to know what that is. A well-known robot from our past and perhaps intellectual property lawyer of the future. Thank you.